to the Two Gurus Talk Compliance podcast with me, Kristy Grant-Hart. I'm here with the one and only Tom Fox. This week, we're talking about how big the Boeing monitorship might get, Italian raids on luxury brand manufacturers for modern slavery, the state of risk assessments according to this year's biggest survey, and Florida man's feudal gun battle with a Walmart drone. But first, Tom, how has your week been? What do you think is the most interesting development?
I was sick all last week, so I missed my favorite holiday of the year, July 4th.
Mm.
And so that sort of set the tone for this week. But I will announce that as of 3 minutes ago, England is marching into the UEFA World Cup finals, having beat the Netherlands 2-1. Things are looking up, and I know my wife will have a big smile on her face, and hopefully it'll be bigger on Saturday.
Hallelujah. God save the king. Fantastic. Good job, England. Tom, you had an interesting choice this week that I've never seen you make before. You sent me 5 articles from the same publication, and I can see kind of why you did, because they all had very different topics, very different voices, very different ideas. Can you tell us about your choice and then what comes first?
Sure. I decided to focus on articles from Corporate Compliance Insights. Our good friend Sarah Haddon is the EIC over there, and it's a great resource for the compliance professional. One, I really wanted to honor Sarah, what Sarah's got going over there, how much she has meant to the compliance profession over the years by putting all of these articles, at least for my section or my contributions rather. So that's one of the reasons. Two, they were just great articles.
Mhm.
And the more I thought about it, recognizing my unenforced hiatus last week, that I thought these are great articles. There are a lot of topics we haven't taken a deep dive into. One we've not taken a deep dive into at all, which is well-being washing, or as Kristy would call it, the new gate of it.
Go ahead.
We'll love it. And so I just thought, let me pull my selection from these. And a couple of them went pretty deep in ways that you really called out on the sanctions article that we're going to talk about, because in many ways, sanctions can be more nuanced than anti-corruption work that you and I traditionally do. And it really gave the non-sanctions specialist a framework to think through some of these issues in a way that, frankly, I hadn't. So I just found the articles good. I've been wanting to do something for CCI simply because they have been such a big part of the compliance community in terms of a deep dive bulletin board, whereas the FCPA blog obviously was a bulletin board for many years. They were much shorter articles, and that was by design. I don't mean to criticize at all. But Sarah's given people the opportunity to literally take deep dives. She's got some columnists who are well known in the compliance community, and she's got some podcasts up. She is a sponsor of one of the sponsors of the Great Women in Compliance podcast. So that alone probably Raider sub kudos. So anyway, I just thought it'd be great to pull 5 articles. They're topical articles, and one of us mine. So we're going to
Let's
start with that
with the
one,
best one, Tom. Let's start with the biggest and best.
the biggest and best. So I've been thinking about this issue for a long time, Kristy, which is how can the DOJ best resolve the Boeing issue? The issue coming out of its prior DPA for the 2 737 MAX crashes, the violation of that DPA, and then moving forward. Now, this is obviously something that's very sensitive because we have 346 families who lost family members in this crash, and they have been unremittingly critical, rightly so, of Boeing. And they want blood, and they want pain, and they want a $25 billion fine. But the more I thought about it, Kristy, the more I looked at it, Boeing has not simply multiple constituencies and stakeholders literally all over the world, but it is one of the most ubiquitous U.S. companies. It is in at $77 billion last year of revenue generated. It is fully half of 48% of all Americans flew last year, and we flew on Boeing jets largely. So that's you and me. And it's a huge harbinger for the national economy and the international economy. It's a huge component of NASA. It's a huge component of national security. And for all of these reasons, I think a continued punitive approach will not resolve the issues. Boeing needs help, and they need help in a wide variety of areas. Obviously, airplane manufacturer is one, but culture is one, is one, worker safety, speak up, whistleblower. All of these and many more need to be deeply looked at. And I think that the DOJ, my imploring to the DOJ is don't think about one monitor to come in and fix their compliance program. Let's take this opportunity and the DOJ lead this effort to fix Boeing, to fix all parts of Boeing. And my proposal is that we have one sort of omnibus monitor, but under that, we have multiple subject matter expertise monitors. And as I articulated, airplane manufacturing, health and safety, culture, whistleblowers. Um, I think I listed 10 different categories in my blog post. Is it going to cost a lot of money? You bet it's going to cost a lot of money. But Boeing ought to openly embrace this because Boeing has to get this right. They have got to get back on track. We can't have doors blowing off planes in Alaska where I don't know if you ever think about those sorts of things. I try to put them completely out of my mind because I would go crazy if I did. But if we can't be safe, it's going to destroy the US economy if we can't fly safely. Every airline depends on Boeing. And as I said, down to you and I depend on Boeing, and our loved ones depend on Boeing. So I really want the DOJ to maybe step back and say, let's go about this in a different way. Boeing needs help. Let's give them the help. Let's give them the subject matter expertise. We'll have the hammer of the DOJ. We'll have the hammer of the U.S. District Court. I hope Boeing would embrace this opportunity. But if they don't, guess what? They have to because they've agreed to plead guilty. And heaven forbid, they pled guilty, said they fixed it, and yet 18 months later, here we are again. The punitive phase is going to kick in at some point, and we can't afford for that to happen. We've got to have Boeing up and running. It is one of two international airline manufacturers, the biggest in the United States, one of the biggest employers in the United States. And I just think it's my plea, Kristy, is for all of us to think big and to think of ways that we can collectively help Boeing get back to the point where if you ain't on Boeing, you ain't going, which was a tag phrase from the 80s and 90s. I just think it's an opportunity for the DOJ to use a tool in a way they have not done so before. This, in my mind, could be not simply the biggest, but most important monitorship they've ever had. And let's get out of the box. Let's think differently. Let's help Boeing. Boeing's going to have to pay for it. This is not coming at the nickel of the U.S. taxpayer. And if they lose profits for X number of years, that's just the price they're going to have to pay to fix themselves because they put themselves in this situation and they don't seem to either have the will or the way to get better. Wow, you really got me off on the soapbox
Yeah,
today.
man, that's quite a soapbox. I was okay. We got soapboxes all over the place here at Two Reviews. One of which is frequently stood on is this monitoring activity or this monitorship. The fact that we actually are getting one, I mean, it would be pretty egregious to imagine a place we didn't if this weren't it. But I do think that you have a lot to say here about the value of a larger, more sort of omnibus way of looking at this. Do you think that is likely? I mean, I know that there has been pleading guilty, and I know we're still early. I don't think they've announced a monitor yet, unless I looked yesterday and I hadn't seen it. Do you think that this is likely, or who's making the decision of how big and how robust this is going to be?
The DOJ has announced that they're going to take proposals. So there'll be a formal written RFP process. We will be in U.S. District Court on a criminal plea. So the U.S. District Court judge will have oversight over this as well. This is not the situation where they're just coming in and saying to DPA, stamp it.
Right.
This is a guilty plea. So the court will have input. I didn't even mention the FAA, who is a huge part of this.
Yeah.
And the FAA, I'm sure, will have their own set of monitors, overseers, whether FAA or outside experts or not. So they're going to be a huge part of this. So it'll be a massive interagency effort as well. And I just hope that we can use this opportunity to fix Boeing.
Oh my, we are spending a lot of time here today talking about big name companies, and we're going to move from Boeing to two luxury Italian companies. This story is from the Wall Street Journal. It's titled Raids Find Luxury Handbag Being Made by Exploited Workers in Italy. Again, kudos to the Wall Street Journal for this really terrific reporting. This story focuses on the investigation of prosecutors in Milan who were looking at working conditions at local factories making handbags and other fancy leather goods for two very high-end Italian fashion brands. The court rulings criticized the brands for failing to adequately oversee their supply chain. And while the companies themselves won't face charges relating to these findings, the independently owned suppliers may face charges of worker exploitation and employing workers without proper documentation. So the article notes that the high-end brands knew that the Made in Italy label is important to their customers, which is why they manufacture there despite paying workers 2 to 3 euros an hour, which is totally illegal in the country. Unfortunately, the manufacturers they used were people who were brought in as foreign workers, many of whom were Chinese and not working under visas to be in exploitative conditions. This included workers working on machines from which safety devices had been removed to increase productivity, always a good sign. And at one of the factories, the workers jumped over the fence to try to escape the raids when they were occurring. The court imposed the equivalent of a monitor on several of the brands in question. A special commissioner, as called, is appointed to oversee operations and provide updates to the court on companies' progress on resolving these issues. So, two things on this. Number one, once again, big names getting in the news for modern slavery issues. First, we have the cars. Now we have the luxury cars. Now we've got the luxury leather goods. And I think that's going to make it driven home more and more. But secondly, we have a modern slavery monitor. So the Italian courts have put in a way to make sure that people are monitoring the activities of these factories so that these things don't happen again. I mean, I can see it. I don't know if there'd be political will, but I can see the US someday going down this path. They could if they wanted to. Do you think that could happen?
I think that's inevitable.
I love that point of view. I think it's inevitable. Even better. All right. It's so definitive. It's inevitable. I love it.
I am inevitable.
Fantastic. All right. On that happy note, let's go to people who are maybe not as serious about taking care of individuals as the Italian courts are to try to make things better. What's going on in article number 2 that you chose, Tom?
So I learned a new term, which is well-being washing. Although I'm persuaded by your 70s moniker, being gate, that we've got something is wrong or askance. And this is really a situation, Kristy, where a company says being is important, but they don't act like it. And they have toxic culture practices, or they've outright lied to you, or, they've said, your well-being is very important until, of course, 9 a.m. the first night you're at work and you get a text from your boss saying, oh, by the way, I need this within the hour. Those sorts of things. So if it turns out, obviously, you're going to, hopefully, you will trust the people that you have hired you and you will give it a chance. But if something happens that is not what you expected, is not the way you expected to be treated, you need to speak up. You need to raise your hand. You need to say, this was not the way it was presented to me. And if the answer comes back, TS, maybe, sorry, did you think we were really serious about that? And what part of 100 hours a week billing you don't understand for those new associates at Goldman Sachs, maybe it's time for you to move on, because if you can't change the culture from within, or you and your colleagues can't, it's not going to change. And so part of that responsibility is on the individual. Obviously, it's much more important for the company to do what they say, but if they don't do what they say, you need to do something, and that may be leave.
Yeah, I mean, okay, so all the washing, right? We've got whitewashing. We started there. Recently, you and I've talked about the greenwashing, and then we got the AI washing, and now we have well-being washing. Oh, there is a lot of buckets and water around here, apparently, to do all this washing. And it does remind me of the word gates, the travel gate and the water gate and the this gate and the that gate. And I dropped red wine at my sister's house once, and it became known as red wine gate. So just a thing. I cleaned up the carpet. She wasn't happy. It was a whole drama. Anyway, But I think when it comes to this is a class, this really sounds like when we started talking about DEI or we started talking about environmental care. It's all the bottom line, is this a culture or is this a PR stunt? And I think that it's really difficult. The article, the author talked about speaking up and challenging the status quo and saying that's not what happened. And I just can't imagine in a place where somebody uses this as a PR stunt and then doesn't follow through that they're going to care about arguing with the policy or say this isn't what I was told it was going to be like. But I mean, I suppose if you're going to leave anyway, maybe it's better to try to make a difference or not before you take off in your whitewater raft.
What do you got for us? Oh, you've got not fun stuff
Oh,
next.
heavens. All right. I had to work really hard to not get into my lawyer dig in weeds here. So I'm going to try to keep this very high level. My article is from my former law firm, Gibson Dunn. Shout out to all the Gibson folks. And it is titled Supreme Court Overrules Chevron, Sharply Limiting Judicial Deference to Agency Statutory Interpretation. So this article tackles the demise of the administrative state at the hand of the Supreme Court. Since 1984, court had been required to defer to an administrative agency's interpretation of statute or the law, as long as that interpretation was reasonable, right? So that means that if the agency's reading of the law would be different than the court itself would have said it was, the court had to say, yeah, but you know what? The administration agency, that's what they do all day long. They understand what it means. That is no longer true. So in real life, this means that courts can second guess how agencies like the Environmental Protection Agency, the Federal Drug Administration, Department of Defense, etc., interpret laws and their application. And that was called the Chevron doctrine. It's now dead. The Supreme Court also brought interesting decisions relating to curtailing the powers of federal agencies like the SEC. So the court reined in the SEC's ability to bring enforcement actions in administrative tribunals rather than federal courts. This all means that there is likely to be a flurry of lawsuits challenging laws promulgated by the federal agencies that the courts will then decide. And in case anyone hasn't noticed, courts have lots of different opinions depending on where you are, like our friends in the Fifth Circuit, where you are, Tom, the Fifth Circuit Court of Appeal. I mean, some of these statutes are going to be interpreted in interesting ways. I saw Matt Kelly wrote today that the demise of Chevron doesn't mean anything for compliance programs or compliance practitioners. I'm not sure I agree. Tom, what do you think? Should compliance practitioners think of things any differently after Chevron's death?
In terms of compliance programs, Kristy, I really don't see a lot of applicability to compliance. The SEC has something literally from almost the ancient past now, the Seaboard Memo from '07, I think, which lays out a structure for a compliance program, but clearly we're way beyond that. Now, 20 or 17 years later, the Department of Justice has issued several statements around compliance. We had the first and second, or FCPA Resource Guide editions 1 and 2. We've had multiple evaluation of corporate compliance programs. And if a company wants to come in and claim they don't have to follow the evaluation of corporate compliance programs, it's going to be difficult to show you don't have an effective compliance program. And I find that type of argument not simply circular, but absolutely inane. Maybe if a company violates the FCPA, they would try to defend it, but frankly, I can't imagine that. The penalties, the potential carrots are so great under the FCPA corporate, or now the corporate enforcement policy of a discount and declination with cooperation and remediation and profit disgorgement. I don't really see in that sphere applying directly to compliance, maybe more back towards the SEC in terms of climate change reporting, ephemeral messaging. I mean, maybe companies will try to challenge that and say they can't be fined. But once again, there you're in the position of these, that the fines around messaging, literally since, I believe, September 2022, have all been against companies that had policies and procedures and didn't follow them. So it's hard to say you can't fine me for me failing my own policies and procedures. That's kind of a per se definition of an internal controls violation. I mean, I'm sure there are going to be some areas that are more SEC focused that companies could challenge. but I just don't see much in terms of this doctrine being overruled that would impact compliance as we practice it right now, Christy, directly. Unless if we took the other position, which is okay, everything the DOJ said is not effective. Guess what? Now companies are like, what do we do? What do we do?
Mm.
And people were screaming in 2010 for the DOJ to put out their what became the FCPA Resource Guide First Edition. They were screaming for the 10 hallmarks of an effective compliance program. And that was a treaty obligation we had under the OECD,
Right.
which was incorporated in the 1998 FCPA amendments. Yeah, let's just geek out on this
Yeah.
because I just don't think it's going to apply to what you and I do on a day-to-day basis or what our clients would ask us.
No, I mean, ultimately, we don't want to be the ones fighting in court that the SEC interpretation of something is the reason that we shouldn't be held guilty for it. We want to be on the prevent side. And speaking of prevention and dealing with difficult laws and interpretation, let's talk about nuanced interpretation when it comes to third.
This one, Christie, is as close as I saw in the 5 articles I suggested to that well-known Howard Sklarism, water is wet. And it really drove home the point, though, and I think you actually have some pretty distinct thoughts on this, or at least discrete thoughts on this, that not only do you need to try to get a handle on what how your organization is using AI, can it be audited, can it be fixed if you get a wrong answer, but you still got those same responsibilities down your supply chain. And that may be a third, fourth, or fifth level because if garbage came into the supply chain at level 5 and it stayed in there information wise, it could corrupt something all the way up. I just thought that it was a good reminder that you, as a compliance professional, are going to have to start looking into these, or maybe you're a supply chain professional, start looking at these things a lot more detailed if you're going to be relying on this type of information going forward. And on the road ahead, it's you need to have transparency in your AI risk methodologies, security around any vulnerabilities and AI application, and consistent AI security policies that you consistently enforce.
So the article was, I thought, a little bit surface level in some ways about, yeah, you should know what your third parties are doing with AI. But I think that when you dig into how this is actually being done, it's really interesting. By the time this comes out, I will have finished, maybe, I'm not sure, doing a webinar with Diana Kelly, who is an AI expert that I saw at Compliance Week. Phenomenal. And she started talking about real applications, like most of your adhesion contract are going to say that the companies that's working with it has the right to use the data as long as it's anonymized. And she said people's company-wide data is being used to train AI models for third and fourth parties that they have no idea that it's being done. And that's the kind of thing where I think it's a very concrete, understandable way of saying, okay, so I told you you can't use my personal data. However, comma, I can use your data in aggregate. And as Diana said, it takes one step to unanonymize most data. It's really not that difficult to do, especially if you have AI helping you unanonymize it. So there's all kinds of things I think are important here. But yeah, we need to be more able to scrutinize what's happening in that AI world, especially with third parties, fourth parties, and understanding what those contract terms mean is critical.
So what's Navex got for us this week, Chrissy?
Navex, I'm going to be getting on my soapbox, not with Navex because they're great. But what I did recently, I was lucky enough to co-host a big webinar with Carrie Penman of Navex. And we went through the results of their incredibly large survey of compliance professionals about the state of risk and compliance. So I would like to focus on 2 statistics in the mountain of data that they on the first relates to risk assessment. So Tom, soapbox again. Every single compliance program should have a risk assessment guiding it in using a risk-based approach to resource allocation. I do not think that is a terribly controversial point of view. However, are people doing it? No. So I hosted the same webinar last year and I was literally shocked because the statistics showed that 71% of respondents had a current risk assessment. This year it had to be better, right? Oh no, it was worse. We've gone down to 70%. So 1/3 of people responding to this survey do not have a risk assessment. And what's worse, this one, only 44% of the people who had a risk assessment at all reported that it resulted in a risk tailored allocation of resources to higher risk areas. Okay, half of them have a risk assessment, but it doesn't inform their choices. So that's smart. What else? When it came to training plans, only 69% of respondents said their organizations had one. 21% said they did it, which 10% of people responding weren't sure if they have a training plan or not. So, pro tip, if you don't know if you have a training plan or not, you don't. So, really, so if my math is right, approximately one third of organizations responding to the state of risk and compliance survey don't have a risk assessment and or a training plan. What is the world coming to, Tom? Did those surprise you? Was the risk assessment statistic more surprising? Was the training plan statistic more surprising? I mean, training plans, compliance 101. What do you think?
I think you're right if you have to ask, "Hey, where's our training program?" You probably don't have one. I was when I read this section that you wrote up, I could just see you getting more worked up through each bullet point going forward. And I could hear you in my head. We've been doing this so long. So part of my laughing is it was just that's exactly what I expected from you on on this one. Yeah, this part on risk assessments. I mean, what do you have a sense of? Is this people who don't know how to do it, who management will not let them do it? I've worked in companies where management didn't want a risk assessment done, and so that was one way that prevented this, but this number is just beyond belief. Any sense of why we're still at this number?
My personal sense is that a lot of people are uncomfortable with risk assessments, especially when we have very analytical thinkers, or lawyers or accountants in our profession who find it's an art, not a science thing, very uncomfortable. I think it's also easier to jump into training or policies than to try to figure out an assessment methodology. So I can at least understand a little bit, but the half of them that don't use it to inform their program, that's really where I can't handle it. You've done the thing, but then you didn't use it to do any in terms of how you're actually running your program. We have there are places to grow. I guess maybe I'll put a positive spin on it. We have continued improvement opportunities that we need to do over time.
There you go. Opportunities for improvement.
Exactly.
Okay. So my next article, first of all, I want to shout out to Chris Sidnick. Chris is the author of this article, and Chris and I worked together in 2015 and haven't really talked with Chris a lot since we worked together, but he is one of the smartest people in compliance, and he is exactly the kind of person to put this article together. He excels at taking a large amount of information and synthesizing it down. And I think he's done so in this article. And so, kind of part one. Part two is what he has shared with us, Kristy, is a common difficulty for non export control and non trained trade sanction compliance specialists who don't do this every day. And that's when you get multiple hits or screenings with incomplete information, or how do you figure out if the name that has come up or name being used that you're trying to run check on is any number of nefarious characters that would cause you concern. So things like common name, a lack of clear secondary identifiers, a hit on a parent company, but different than the entity that you're trying to look at, something that appears to be a state-owned enterprise, sanctions from years ago that may have been removed, and unclear details on sanctions. These are all things that, for my sins once in the corporate world, I was put as the head of our export controls department. And these are things that drove me crazy because I didn't know how to clear them. And Chris really lays out how you would think through getting secondary information or secondary identifiers, as he calls them. And it can be something, Christy, as simple as a passport photo or a government issued driver's license photo, even if that driver's license is issued by someplace outside the United States. When you're comparing pictures and ages and genders. These sort of basic information can be a huge help on clearing things. And it may take a step or two. And I don't pretend to say that it won't be, doesn't require some work, but it allows you to clear things more quickly and more efficiently. And Chris really lays out the type of information you need, how you can get it, and how you can use it going forward.
I don't want anyone to read this article because if they do, then they'll understand exactly how we put together some of our best advice for clients, which we put together a whole red flag clearing matrix that is based on what do you do when and if. And that comes from my experience working at the giant travel company where I was in charge of trying to clear sanctions for people, where one of the people on that list, the sanctions list that year, was Mohammed. Mohammed is the most popular name in the world. So you end up with all kinds of fuzzy matches and what do I do and how do I prove kind of things. So I really think if you are new in the sanction space or you're uncomfortable, this is required reading. It so clearly lays out how to think about these problems and how to have a defensible, consistent way to clear them. It's really good. So cheers to him. That's excellent. Okay.
What do you got next for us?
All right. Let's go back to wellness washing. For those who work at companies that don't even pretend to care about well-being, this story is for you. So it is from the Washington Post, and it says, "Is work taking over your life? Here's how to reclaim your time." So the opening line of the article made me laugh out loud. It starts by saying, "Work-life balance is in danger." Okay, good. Okay, so it's not already dead. It's maybe that's just me. So for employees facing the death of work-life balance, this article gives 5 ways to take back your time, some of which were quite creative, I thought. So the first recommendation is to set boundaries, but to tell people about them in creative ways. The article recommends using your email signature to note the hours that you work, how long it typically takes for you to respond to emails, and what to do if you have an urgent request. Next, they suggest scheduling your communications to be delivered during working hours of your colleagues with the expectation they'll do the same for you in response. And if not, you can ask them to, as a reciprocity suggestion. Another is to fill your calendar with buffer times so that you have space to be actually doing work as opposed to just meeting. I have my assistant do this. Every once in a while, I look at my calendar. It's terrible. And I'm like, you have to put lunch there. Sometime there has to be lunch. So she actually does that, which is really helpful for me. And the last suggestion is to use the do not disturb feature on your phone, Teams, and Slack to let people know you are not paying attention to the messages, which I think are good. Now, Tom, I laughed at this because when I saw this article and I was writing it up, it made me think of your email signature if this were structured in the way that the article suggests. So it would finish something like best Tom Fox and say, my working hours are all, usually I respond in minutes. If it's an emergency, don't bother looking for me because I'm not answering. I've probably already succumbed to the zombie apocalypse. I think that maybe not as successful for you in creating your bound, but I do. No, setting your expectations right in your signature. It's
Yeah.
how'd I do with your email signature? I think you should try it for a week and see what happens.
Mhm. Yeah. Well, I'll tell you what, I'll make this commitment to you. I will mention this to my boss and I will see what he says.
Excellent.
How about that?
Why don't you report back next time and tell us what he said? All right.
Got it.
Okay. Now, the last one of the CCI extravaganza. What do we got?
So this is really a touch point on the international comm surveillance compliance efforts. I hit on this a little bit earlier in one of my other rants or raves, but clearly the U.S. government in the form of Securities and Exchange Commission, FINRA, the regulated industries are going to maintain robust enforcement actions around this. I think the article talks about the financial, the FCA in
Financial
England.
Conduct Authority in the UK.
Yes, I think they're going to ramp up and start enforcement actions as well. We had one enforcement action, this FCPA enforcement action this spring, where this was an issue. I could not tell from the discussion how the DOJ may have evaluated it in terms of additional penalties or credits. The company certainly didn't get credit because they were criticized for having ephemeral messaging, which was not captured. This is going to continue to be something on the government radar. If you're in the regulated industries, this is not a nice to have. This is a must have because it's by regulation. And if you're a U.S. public company, it's coming. So get ready. And you're going to have to decide what you're going to do in terms of giving everyone a device? Are you going to put everyone on a BYOD? If so, how are you going to monitor their device? Are you going to be able to get that if you're in Europe? Are you going to be able to get the information off their device if it's subject to GDPR? It's a whole list of issues, but you really have to have a thoughtful process in place. This is not going away because from the regulatory perspective alone, it's too important. And they don't want companies doing business on messaging that cannot be captured later if necessary. And for people who think this is new, I did trader litigation in the 90s and everything was recorded back then. So this is nothing new. It's just a different form of recordation and more technologically advanced with the time. So I really wanted to end with this to re-emphasize US regulators are going to continue to hammer on this. I think the FCA is getting ready to unleash in London as well. And I think it's going to become a little more ubiquitous across the globe.
Yeah, I really liked FINRA's suggestion of monitoring. I had never thought about this before. They said that one of their suggestions was for the compliance officer to look at how frequently the correct channel systems are being used for communication. So if you know that Slack or Teams or one of the others that is available to people isn't being used or is being wildly underutilized, that should be a red flag to you to go and find out what they're using instead. So I thought that's a pretty clever way of doing some monitoring. Add that to your monitoring plan and figure out if there's only 4 messages in the last month and a half, what are they actually speaking on is a pretty smart question.
Is Florida Man with us this week, Kristy?
Obviously, Florida Man is with us. He is always with us, both in our hearts and in our news stories. So we will close with Florida Man. This Florida Man is 72-year-old Dennis Wynn, and he knows that he is a good shot. And how does he know this? I will tell you. On June 26th, Wynn noticed that a drone was flying near his house. He tried to shoo it away overhead, but when that didn't move, he decided that it must be watching him. So as it descended and moved away from his house, he did what anyone would do in the situation and got out his 9mm handgun and shot at it. So as it turned out, the drone belonged to Walmart. This store was piloting a program featuring mock deliveries to attract business in the area. Now, the poor drone suffered $2,500 worth of damages to the payload system. Wynn was charged with criminal mischief damage over $1,000, firing a gun in public, and shooting at an aircraft. He seemed both pleased with himself and concerned on the body camera footage of the police when he said, quote, "I fired one round at it. They say I hit it, so I must be a good shot, or else it's not that far away. I'm going to wind up having to find a real good defense lawyer," unquote. Yes, Florida Man, but at least in jail, there aren't drones overhead.
God bless Florida Man.
Florida Man to the rescue. Thank you for joining us. I'm Kristy Grant-Hart.
And I'm Tom Fox.